Slaves can possess nothing, being property themselves. They can own no property, nor make any contract. Man was created proprietor of the earth, with dominion over the beasts of the field. The humanity of the slave is denied. By denying to him any share in this original right of human nature or capability of its exercise, he is not ranked among sentient beings, but among things. A chattel cannot be the owner of a chattel. The slave can possess nothing nor acquire anything but what must belong to his master. Civil Code, Article 35. They cannot take by purchase or descent. Slaves have no legal rights in things, real or personal, but whatever they may acquire belongs, in point of law, to their masters. Stroud, pages 25 and 45. Slaves can make no contract. Stroud's, pages 25 and 61. Slaves are incapable of inheriting or transmitting property. Civil Code, Article 945. By the Roman law, the slave might possess what was called his peculium, or what his master might, by stipulation, accord to him, and which, having thus stipulated, he could not afterwards take from him. By this law, slaves acquired property, sometimes embarked in commerce, redeemed themselves and amassed fortunes, or, in other cases, without an absolute purchase of themselves, paid their masters an annuity, as the price of their services, and attended to their own affairs. Not so in Republican and Christian America. The legal relation here is another thing. The only exception, approximating the Roman Code in this particular, so far as we know, is found in the Civil Code of Louisiana, as follows. All that a slave possesses belongs to his master. He possesses nothing of his own except his peculium, that is to say, the sum of money or movable estate, which his master chooses he should possess. Article 175. C1 Martin's Digest, 616. Yet, in the same code stands the following. Slaves cannot dispose of or receive by donation, inter vivos or mortis causa, unless they have been previously and expressly enfranchised conformably to law, or unless they are expressly enfranchised by the act by which the donation is made to them. Article 1462. The earnings of slaves and the price of their service belong to their owners, who have their action to recover the amount of those who have employed them. Louisiana Code of Practice, Article 103. Except in the permission of a peculium, the laws of the other states on this subject are similar to those of Louisiana. South Carolina, slaves cannot take by descent or purchase. Poor Desaussures Chancery Reports, 266, Bynum v. Bostwick. North Carolina, slaves cannot take by sale, or device, or descent. A device of land to be rented out for the maintenance of a slave was adjudged to be void. 1 Cameron and Norwood's Reports, 353. Same decision. 1 Taylor's Reports, 209. Maryland, a gift, bequest, or device made to a slave by anyone not his owner would be void. See Dulaney's opinion, 1 Maryland Reports, 561. Though such a device of real or personal estate, made by the owner of a slave, has been held to entitle him to freedom, as the implied intention of the owner. Hall v. Mullen, 5 Harris and Johnson's Reports, 190. In Wheeler's Law of Slavery may be found ample evidence that this feature of the slave code, the incapacity of the slave to possess property, is not a dead letter, but recognized by the courts and enforced whenever there is occasion, not only to the letter of the statute, but by an application of the principle and spirit of the enactment, in a contingency which legislative sagacity did not, probably, foresee. A slave, for instance, accidentally found a sum of money in bank bills, which someone took from him and carried to the bank. The owner of the slave boy brought an action of trover against the bank for the sum, and recovered it by judgment of court. Judge Safford said, "Our slaves can do nothing in their own right, can hold no property, can neither buy, sell, barter, nor dispose of anything without express permission from the master or overseer, so that everything they can possess or do is, in legal contemplation, on authority of the master." Judge Crenshaw said, "A slave is in absolute bondage. He has no civil right, and can hold no property, except at the will and pleasure of his master. A slave is a rational being, and endowed with understanding and volition, like the rest of mankind, and whatever he lawfully acquires, and gains possession of, by finding or otherwise, is the acquirement and possession of the master. A slave cannot take property by descent or purchase." Brandon and others versus Merchants and Planters Bank of Huntsville. 1 Stewart's, Alabama, Report 320. S.P. Bynum versus Bostwick, 4 Desessor, 266, Wheeler's Law of Slavery, pages 6 and 7. In the preceding decision, the manhood, the reason, the understanding, the volition of the slave are distinctly recognized, and for the express purpose of claiming all the acquirements of such a being as the property of his master, equivalent to the claim of absolute proprietorship in the human soul itself. The theory and the practice of slavery are here found to be in harmony, and the courts enforce the enactments of the legislatures. In a note to the preceding decision, Mr. Wheeler says, page 7, "These principles prevail in all the states, and are taken from the civil law, and were adopted in all, except Connecticut, and perhaps Massachusetts." Hall versus Mullen, 5 Har and John M.D. Report, 190. The court held that no legal contract whatever could be made with a slave without the consent of his master, page 7. In Jackson, upon the demise, the People versus Lurvy, 5 Cowan's Report, 397. The court held that a slave at common law could not contract matrimony, nor could the child of a slave take by descent or inheritance, page 7. Free Lucy and Frank, Fall Term, 1826. 4 Monroe's Report, 167. Emerson versus Howland, 1 Mason's Report, 45. The court held that contracts made by Negroes while in slavery do not bind them when liberated, and consequently a plea by a free Negro that a writing sued on was delivered when he was a slave is good, page 190. In a note on this topic, Mr. Wheeler says, "One general principle prevails in all the states, and in the British, Spanish, and Portuguese West Indies, and that is, that a slave cannot make a contract, not even the contract of matrimony," and he cites numerous authorities for the statement. Page 190. The slave is thus taught that his promises and agreements are of no binding force. Even the free Negro, as has been seen, is taught the same lesson in respect to his former condition. Yet those by whom these lessons are taught affect to marvel at the moral obtuseness of the Negroes, and consider themselves as occupying a high moral eminence above them. A warrant for 1,000 acres of land issued to a slave in Tennessee for military services as a musician during the Revolutionary War was adjudged to be the property of his owner in 1834. This decision was made against the claims of an heir of his former owner, Colonel Patton, a Revolutionary officer, who caused his slave to be enlisted. No claim appears to have been set up on behalf of the slave. See Wheeler's Law of Slavery, page 229. Though a slave can make no contract on his own account, yet his master may constitute a slave his agent for the most important pecuniary transactions. We once knew of a prominent public man whose personal credit in his market town was so low that his written order on his merchant for $50 worth of goods was rejected. But when his managing slave stepped forward and promised that the next loads of produce should be delivered in payment, the answer was, "Very well, Cuffy. If you say so, I'll deliver 10 times the amount of goods." Chastain versus Bowman and others, May term 1833. One Hills, South Carolina reports, 276. The court charged the jury that a slave might be the agent of his master, and if his agency was established, the master was bound. Verdict for the plaintiff, and motion for a new trial. A court decision made by a group of judges. Johnson J. It is not questioned that a master may constitute his slave his agent, and I cannot conceive of any distinction between the circumstances which constitute a slave and a free man an agent. They are both the creatures of the principle, and act upon his authority. There is no condition, however degraded, which deprives one of the right to act as a private agent. Motion dismissed. Wheeler's Law of Slavery, page 228. It is certainly remarkable that a man should have a right to act as an agent for another who can have no right to act for himself. Equally remarkable is the plea that slaves cannot take care of themselves and must be benevolently superintended for their benefit while they conduct the business of their masters. The slave is adjudged to be a mere thing, except where his master's interest or convenience require that he should be regarded a man. Another curiosity of slave jurisprudence deserves notice here. Although it is adjudged an offense against the state for a free white citizen to hold honest commerce with a slave for the beneficial and useful purposes of life, to employ a slave to labor and to pay him just wages, an offense. Likewise, for the master of a slave to permit and authorize such transactions, as will be shown presently. Yet, according to Wheeler, it is not an offense, either at common law or by statute, to gamble with slaves. This statement is his marginal title to the law case of the State versus Pemberton and Smith, December term, 1829. 2 Deveraux, North Carolina report, 281, in which, after verdict for the state, His Honor Judge Strange arrested the judgment, being of opinion as before stated. From this judgment, the solicitor for the state appealed, but the judgment of the court below was affirmed. Wheeler's Law of Slavery, page 441. With exception of Louisiana, as already mentioned, our American slave states have signalized themselves by special enactments to prohibit the possession of the smallest amount of property by the slave, even with the consent of the master. The Greeks, the Romans, the ancient Germans, the Poles with the Portuguese, the Spanish and the French of our own times had provided, both by law and by custom, for the possession of property by the slave, which could not be seized by his master. In the British West Indies, though no written law had sanctioned the custom, a public sentiment had indulged the slave in the enjoyment of some petty possessions, and had forbidden the master to interfere with them. But this lenity was manifestly inconsistent with the absolute and unlimited chattelhood of the slave. A principle was seen to be involved, which, if tolerated in an age of inquiry, would undermine the whole system. If the slave could possess property, he could dispose of it. He could make contracts. He might contract marriage. He might become a man, and, becoming such, cease to be a slave. The safety of the entire fabric required that not one stone in the edifice should be missing. And besides, the idea that a slave can possess property, however trifling the amount, is the idea that the slave has rights, an idea that must by no means be permitted to enter the mind of the slave or be entertained by the community around him. Especially must this not be done in a land wherein human rights have been discussed and proclaimed. The jealousy, the vigilance, the sagacity, the appliances of a grim despotism are never so severely tasked as in the presence of the spirit and the doctrines of freedom. This single thought solves the enigma and repels the opprobrium of an unprecedented tyranny in a land wherein are taught the principles of liberty. A despotism in such a country must be doubly despotic or die instantly. The reader has, in these suggestions, our philosophy of the remarkable enactments that follow. South Carolina, it shall not be lawful for any slave to buy, sell, trade, etc., for any goods, etc., without a license from the owner, etc., nor shall any slave be permitted to keep any boat, periauger, or canoe, or raise and breed for the benefit of such slave any horses, mares, cattle, sheep, or hogs, under pain of forfeiting all the goods, etc., and all the boats, periaugers, or canoes, horses, mares, cattle, sheep, or hogs. And it shall be lawful for any person whatsoever to seize and take away from any slave all such goods, etc., boats, etc., etc., and to deliver the same into the hands of any justice of the peace, nearest to the place where the seizure shall be made. And such justice shall take the oath of the person making such seizure, concerning the manner thereof. And if the said justice shall be satisfied that such seizure has been made according to law, he shall pronounce and declare the goods so seized to be forfeited, and order the same to be sold at public outcry. One half of the monies arising from such sale to go to the state, and the other half to him or them that sue for the same. James Digest, 385 and 386. Act of 1740. Georgia. The statute is nearly the same as in South Carolina, with this additional prohibition, lest the master should sometimes permit the slave to hire himself to another for his own benefit. The state imposes a penalty of $30 for every weekly offense on the part of the master, unless the labor be done on his own premises. Prince's Digest, 453 and 457. Kentucky, the same, with a slight modification. Tennessee, similar. Act of October 23, 1813, Chapter 135. Virginia. If the master shall permit his slave to hire himself out, it is made lawful for any person, and the duty of the sheriff, etc., to apprehend such slave, etc., and the master shall be fined not less than $10, nor more than 20, etc. 1 Revised Code, A.D. 1819. 374 and 375. Mississippi, same as in Georgia and Kentucky, before stated. Revised Code, 375. A slave in Mississippi is forbidden to raise cotton for his own use, and should the master permit him to do so, he incurs a fine of $50. Revised Code 379. Further, if any master, etc., of a slave license such slave to go at large and trade as a free man, he shall forfeit the sum of $50 for each and every offense. Revised Code 374. See also North Carolina. An equal fine is imposed upon any master convicted of permitting his slave to keep stock of any description. Act of January 29, 1825. Pamphlet, Laws of Mississippi of 1825. Missouri, same as Virginia, before stated. 2 Missouri laws, 743. Hayward's Manual, 534. Also, same as Mississippi. Third specification, just stated. 2 Missouri laws, 743. North Carolina, Act of 1779. All horses, cattle, hogs, or sheep that, 1 month after the passage of this act, shall belong to any slave, or be of any slave's mark, in this state, shall be seized and sold by the county wardens, and applied, 1/2 to the support of the poor of the county, and the other half to the informer. Hayward's Manual, 526. Same or similar law also in Mississippi. Revised Code, 378. Same also in Maryland. Act of 1723, Chapter 15, Section 6. Kilty's Laws of Maryland. And so the white poor are to be fed by plundering the colored poor. Maryland. See last preceding item. Also Mississippi. Third item there stated. See Kilty's Laws of Maryland, Act of April, 1787. Chapter 33. By Act of April Sessions, 1787, any person who shall permit and authorize any slave belonging to him or herself, etc., to go at large himself or herself within this state, shall incur the penalty of £5, $13.33, current money per month, except 10 days at harvest. The penalty was increased to $20, excepting, however, an additional 10 days in harvest. Act of December Sessions, 1817, Chapter 104, Section 1. By both acts, a slave being a pilot is not included in the prohibition. No person shall trade, barter, commerce, or in any way deal with any servant or slave, etc., etc., without leave or license first had from such servant or slave's master, dame, or overseer, for his or her doing, under penalty of 2,000 pounds of tobacco, etc. Laws of Maryland, 1715, Chapter 44, Section 11, 12, 13. District of Columbia, under exclusive jurisdiction of Congress, same as in Maryland. It may easily be conceived that this law would be inconvenient and disadvantageous to many owners of slaves in or near maritime towns, where job labor or labor by the day or the hour might be picked up by the laborers themselves better than by their owners. In such localities, the strict letter of the law could not always be rigidly enforced. The public convenience, the wants of everybody who must needs employ transient laborers, would interpose obstacles. It is known that in Wilmington, North Carolina, a port from which much lumber used to be shipped, which needed much cooper's labor in the preparing, the work was often or commonly carried on by slaves, who paid a large monthly stipend to their owners. Stevedores, who stow away cargoes, caulkers, riggers, and perhaps ship blacksmiths, and even sail makers, being slaves, were allowed the same privilege. The custom had an elevating effect on the slaves, and was therefore looked upon with jealousy by masters not interested in such arrangements. This was 30 years ago. The present usages are unknown to the writer, who gladly presents this one brighter spot in the picture. But it must not be forgotten that all the surplus earnings of these slaves, if any, over and above their support, after having paid $10 or $15 monthly to their masters for their time, is nevertheless, in the eye of the law, the property of their masters, and they can take away, if they please, whatever they find in their possession. The convenience and interest of the planter might permit or even direct the slaves to cultivate small patches of vegetables near their cabins for food by Sunday labor for the most part. In Spanish Florida, this was a custom, It may obtain to a small extent in other states, without serious violation of the letter or spirit of the statutes quoted. Such small and transient supplies would hardly be accounted possessions or property. That the statutes quoted are not commonly regarded a dead letter may be seen by reports of judicial decisions, as compiled by Mr. Wheeler, who expressly refers to the statutes as the ground of the decisions. And in a note he adverts to some of their provisions which we have not yet mentioned. By the Revised Code of Virginia, A.D. 1819, Volume 1, page 442, Section 81, it is declared that a slave going at large or hiring himself out may be committed by a magistrate, who may fine the owner and may order the slave to be sold. Also, by the Revised Code of Mississippi, 374, Section 25, in certain cases, the slave may be sold, and by Section 20, any citizen may seize a slave offering articles for sale, and take him before a justice of the peace, and the justice shall order the slave to be whipped, and forfeit the article to the person apprehending the slave. Wheeler's Law of Slavery, page 153. It is preposterous to suppose that such modern enactments, holding out such inducements to informers and prosecutors, should remain a dead letter. Mr. Wheeler adds, similar provisions are to be found in the statute books of those states where this species of property is recognized. Wheeler's Law of Slavery, page 153. In the same note he had before said, the statutes of the states contain a prohibition with a penalty against the slave going at large or hiring himself out. Page 152. He cites the law of Alabama in particular, and Judge Hitchcock of Alabama says of his book, I have no doubt it will be a valuable work for the use of the members, particularly of the Southern Bar of the United States. He understands, of course, that these laws are to be enforced, as in the following instance recorded in the same valuable auxiliary of the Southern Bar. Jared versus Higbee, 5 Monroe's Kentucky Report, 546. Jared brought trespass against Higbee for taking and imprisoning his slave. Defendant admitted that when he took the slave up, he produced a pass from his master, which gave him permission to bargain and trade for himself until the 1st day of May next, and also for to pass and repass from Livingston County, Kentucky, to Monongahela County, State of Virginia, etc., dated 26 September 1822. The following is from the Judicial decision. A court decision made by a group of judges, that the master shall not let loose his slave, with a permit for him to violate the established order and economy prescribed by law in relation to slaves, is due to society, without abridging the lawful powers of the master to use his property in the slave. It may safely be declared that this paper, given by the master in, to, the slave, violated that duty which he, as owner, owed to the laws of society. These permissions, and such acts of the slave, are violations by master and slave of the policy, spirit, and letter of the statute of 16th December 1802, against permitting the slaves to go at large and hire themselves. Such licenses would tend to beget idle and dissolute habits in the particular slaves so indulged, as well as in others, and to lead to depredations upon the property of others, and to crimes and insubordination. To such licenses and indulgences, society are not bound to submit. The master has no right to give such. It was not a lawful pass or permit. It was a species of temporary and unlawful manumission, etc. Wheeler's Law of Slavery, page 269 through 270. In other language, the statute and its enforcement are deemed necessary to the security and the perpetuity of slavery. It deserves a special notice that this decision was made in Kentucky, where slavery is said to be exhibited in its mildest form. and where the privileges of slaves are greater than in most of the other states. It is not known that in any other nation, ancient or modern, the robbery of the poor has been carried, by system, to such a pitch as to prohibit the mass of the laboring people from holding the smallest article of property as their own, or from making any bargain or contract. And it ought to be noticed and remembered that this condition of things has resulted from an extreme solicitude to protect from danger the so-called legal relation of owner and owned, of master and slave. I republished the American Slave Code in exact accordance to this 1853 publication. If you would like to purchase the American Slave Code, you may do so by visiting the description area under this video. Click the link to the book patch. There you will be routed to this book. I thank viewers in advance for the purchase of the American Slave Code, as your purchases greatly support this channel and the intense work involved in the republishing of history by first-hand eyewitness account.